Hello and welcome to Workforce Wisdom. I'm your host, Christy Bray, Chief Strategy Officer at PracticeLink. This podcast focuses on the latest trends in healthcare recruitment while showcasing innovative strategies, success stories, and fresh perspectives affecting the healthcare workforce. These episodes will lead to in-depth, thoughtful discussions with recognized industry-leading healthcare professionals, exploring the challenges of healthcare recruitment and beyond. Whether you're an experienced recruitment professional or just starting out, this podcast aims to help you discover how experts are reshaping the industry, leveraging technology, and fostering inclusive hiring practices. Today's episode, Workforce Wisdom, Immigration Insights for Smarter Healthcare Recruitment. I'm happy to welcome Elissa Taub to the show today.
Hi, good to be here.
Thanks for joining us. Elissa Taub is a partner with Siskind Susser, and she leads the firm's healthcare immigration practice. For over 18 years, Elissa's legal practice has focused on helping healthcare organizations manage and successfully navigate the immigration process for their international hires. She brings a wealth of expertise in physician immigration matters, including J-1 waivers, H-1Bs, O-1s, and more. She shares her knowledge through co-authorship of the Physician Immigration Handbook, and through frequent presentations on webinars and at conferences. Thank you, Elissa, for joining me today, and I will share my gratitude along with the rest of the recruitment world for your publication of the Physician Immigration Handbook. I know it has been a staple for many years at APPR along with other regional conferences.
So it's my pleasure. We love getting that in people's hands. I know a lot of folks rely on it for handy information. So I'm glad that it's become a go-to resource for folks.
Absolutely. Well, let's dive right in on the exciting topic of immigration law. I'm sure that you wake up every day jumping out of bed, so excited, but would love to hear just your initial thoughts on the intersection of immigration law and healthcare recruitment today, and then related particularly to high demand specialties, and then maybe rural areas that are underserved.
Sure, Christy. And, I think immigration is one of the tools that organizations have to address the physician shortage. So as we all know, physician recruitment is a really challenging field. There just aren't enough folks to go around, especially in certain locations and specific types of practices. So my mantra, and you've heard me say this before, is that immigration is a tool in a recruiter's toolbox to help with their recruitment. But it's not the end all be all, right? So a lot of times when we have an organization that might just be starting out using immigration, we have them focus on particularly difficult to recruit specialties or particularly difficult to recruit locations. So whether that's your really rural locations or specialties where there just aren't enough fellows coming out of training, so it's maybe hard to get an American citizen or green card holding physician into that position, using immigration to attract those candidates can be helpful. And international physicians oftentimes have incentive to go work in rural and underserved locations. So if an organization has locations, work sites that are in rural areas, or maybe even in urban underserved areas that are, high low income population, things like that, there are really big incentives for international docs to go work in those locations. And so immigration can really be useful to get folks to where organizations most need them.
Yeah, and I appreciate you touching on that. There may be underserved areas within the urban setting. I know when I was in Colorado, we would find that in Denver. Folks would like, wait, Denver qualify? Yeah, in some cases, you do get those where those urban opportunities are available to folks.
Yeah, for sure.
So as a health system is thinking about using this tool in their toolbox to recruit J-1s or H-1s or O-1s, what are some of the biggest immigration-related challenges that health systems face when hiring international physicians?
I think of two big picture limits. The first limit is numbers. Depending on the organization and their characteristics and their location, they may see limits on being able to hire H-1B workers if they're subject to the H-1B cap, which we'll talk about in a little bit, or they may be subject to limits on J1 candidates if their primary method of getting a J1 waiver for a doctor is through their state's Conrad 30 program, which we'll also talk about in a few minutes. But there are specific limits for certain employers, certain locations where you may not be able to readily hire H-1B workers, and you may be limited in the number of Js. So I think number limits are a big barrier. And then the other big picture limit is timing, both in terms of processing times by the government. Sometimes things just take longer than we want them to, and sometimes there's not a great way to expedite or get things pushed forward. And then the other thing is you might not be able to have that physician start exactly on the date that you wanted them to, because if you have a physician on a J, maybe we're still filing waivers for 2025 candidates now, even in April. So if you have a physician who's signing a contract now, they're not going to be able to start work on July 1. That timing's really short. And so that timing consideration of how long is this process going to take and what's a reasonable start date so that everybody can be on the same page. I think those are the two of the biggest challenges we see.
Yeah, I would agree. I think backing into the timing is always a tricky, you're kind of guessing, approximately September 30, October 1st, but you're guessing into some of the rest of the application process and then the delays potentially at the state or federal level, right? So you mentioned we would talk about this. So can you break down the most common visas used in healthcare? So for me, in my experience, J1, H1Bs, the CAP and the CAP exempt, and what that means, I guess, if you could tell the listeners, and then maybe touch on the O1s, because I think that's one that folks may not be as aware of.
So happy to. This will be like the fastest rundown of J1s and H1s that anybody's ever done. But in a nutshell, a very large nutshell, so any physician who has gone to school abroad, they want to come to the United States, almost all of them have to do a residency in the U.S. in order to be eligible for licensure and ultimately go on to become attending physicians. So in order to come to the United States to do a residency, of course, they have to match with the program. And then in order to participate in that program, they have to have a visa to come to the United States. The most common visas that are used for residencies are J1 and H1B. Once a doctor starts off on one of those, they are on their own pathway from that point forward that's going to largely dictate the next several years of their immigration journey as they go into the working world. For J1s, they're the most common. Upwards of 80% of doctors who come to the United States from abroad on visas to do residencies come using Js. And J1s are like a weird animal as visas. There are a lot of immigration lawyers who see that and they're like, immediately they freeze up. They're like, I don't know what to do with that. The biggest thing for doctors who come on Js is that they all make a promise that at the conclusion of their program, whenever that might be, they will go back home for 2 years. And many of them don't want to. They come here because they want to settle in the US and we can use their services. So many moons ago, Congress created avenues for doctors to get that home residence requirement waived. And there are various different ways to get it waived. Doctors can file waivers based on hardship, based on persecution, fears. But the most common types of waivers that doctors seek are where they sign a contract to work for 3 years full-time in an underserved area in exchange for not having to go home for 2 years. And so that's really the essential basis of your J1 recruitment, is getting the doctors into an underserved area or areas where they can work full-time for those 3 years. And then we have various pathways to get there, either through state departments of health, which are those Conrad 30 programs I mentioned, where every state can support up to 30 doctors in a fiscal year. Or you have federal agencies that can support unlimited doctors for those waivers, but they have also different limitations in terms of geography and practice types and things like that they can support. So those are your Js. And then you have your H-1B recruits. And your H-1B doctors come to the United States usually on what is referred to as a CAP-exempt H-1B, because they're going to work at a nonprofit academic hospital for the duration of their residency and probably into their fellowship program. When those doctors finish training, they need to go find a job that is also exempt from that H-1B cap, because otherwise they have to go through a lottery to get further H-1B status to go work for an employer. There are 3 types of cap-exempt H-1B employers: your institutions of higher education, nonprofits that are affiliated with or related to an institution of higher education, and nonprofit or governmental research organizations. And so H-1B CAP sponsorship, we could spend an hour really just talking about that. The thing that sometimes confuses folks is that your doctors who get those J-1 waivers all switch to H-1B status to actually do that work. And those doctors get an automatic pass, right? They don't have to worry about that CAP lottery, which makes it possible for for-profit employers, private practices, for-profit hospital systems to sponsor J-1s as long as they're going to work in an underserved area. On the flip side, your H-1B CAP exemption has nothing to do with being in an underserved area and everything to do with the quality of the employer or the work site in terms of whether it's academically affiliated, nonprofit, all of that stuff. So there's some inherent confusion there. And every time I give a webinar, we talk about this stuff. I'm like, I know this is going to make your head spin, but it all makes sense once you get down into the weeds of it a little bit. Your O's are a different animal altogether. Most doctors don't come to the US on O's for training. You may find some physicians who finish up the last few years of a very lengthy fellowship in O status, but typically O's are used where a physician couldn't get a J-1 waiver that year, the program maxed out, or it was just too late in the season to get one, so we might switch them to O, or where they're maxing out on their 6 years of H-1B time that they can spend, or the CAP issue is just prohibitive for them. And so we switch them to O. O1s are visas for people who have extraordinary ability in their field. And so there's a list in the regulation of about 8 criteria that we have to show at least 3 of in order to qualify somebody as a leader in their field, somebody who has really risen, has a lot of recognition, they're at the top of their field, and you're thinking, how could we do that for somebody who's just about to finish fellowship? But it's not necessarily about that. And don't forget, we have some physicians who work almost a whole career abroad and then come to the States, and they have a lot of heft behind them. A lot of physicians who do really impactful research, even at a junior level. So doing O's for fellows and people coming out of fellowship is something we do every year. And so we use those strategically. My preference is that the doctor is going to get that J-1 waiver, or we're going to deal with the H-1B CAP issue at the outset and not go to the O. But if we have to, it's there if the doctor qualifies. And like I said, every year we've got a few doctors who we have to put into O status because the waiver didn't work out, something. So you may encounter those out there, and they can be a really, really helpful tool.
Yeah, I agree. I think it is interesting when you're sourcing candidates and finding folks. You should know as a health system or a recruiter if you can accept a J or an H and what that looks like. So working with your internal counsel or your outside immigration counsel to know that. I found, though, that even on the candidate perspective, they didn't always know. And I thankfully have had some amazing sourcing partners that they knew all the rules and they could uncover that from a candidate. But is there 1 or 2 key questions that new recruiters could instantly say to a candidate to know if they needed immigration support?
Well, typically the 2 questions that are like the legally allowed questions at the interview stage or at the application stage are you legally authorized to work in the United States, like now? And if we were to offer this job to you, would you require sponsorship to work for us? And so if the person says yes to both questions, then you know that there's some kind of sponsorship needed, and you can continue that conversation and determine, is that something that your organization is able to support? If they say yes to the first question, that they're authorized to work in the US, but they don't need sponsorship, well, that tells you, okay, I don't have to worry about that. Some doctors, and when I speak to doctors, I tell them to do this. A lot of physicians who are on visas are going to come right out and tell you because they don't want to waste your time or theirs or unintentionally go down the wrong path if the employer is not able to support them. So usually there are very frank, open discussions at the beginning of the recruitment process just so that we can determine, is this even something we can consider? Because if a J-1 waiver isn't available, we can't shoehorn it in, right? Like there's no way to make something out of nothing. And, sometimes a physician will say, look, I don't want the waiver. Just put me on the O, I'm fine. And what I usually say is, look, it's fine to do that, but going to the O doesn't negate the need ultimately to deal with the J-1 issues. That home residence requirement doesn't go away. The only ways to get rid of it are to go home for 2 years or get it waived. So if you go to the O, eventually that physician might want to settle down. They might want a green card. They might not want to deal with this having to extend their visa every few years. And they're going to come back and be like, well, I really wanted the waiver. And if you can't give that to me, that may be their impetus to go find other employment. So I feel like it's really important to understand people's motivation from the beginning, know what the short and long-term consequences of certain decisions are. Doesn't mean that doing the O is wrong. It just means that we should go into it with eyes wide open to know what the potential risks are.
Yeah, and you touched on a couple of key points there where as organizations who are able to support these folks, having a process then to move them through the different stages from the H to the J to the O to whatever, but like moving them where they know that they do have to get off the O eventually. And so providing that type of support as potentially a retention mechanism. I worked at spots where they weren't really sure if we would help them for their green card application, because that serves as your retention mechanism to keep them once they've moved, they've established, they have a patient panel in your community, probably a rural community. You're going to do whatever you can to try and support them to continue legally working here in our country. Is that the norm for people to say, cool, we'll bring you in, but we're not going to help you get your green card? Or is that more of what happens in the industry?
I find that most employers will support folks to green cards. I think the big variable is the timing of it. I think understandably, a lot of employers want a physician to onboard and work for at least a little bit of time, even 90 days, just so they can make sure that the physician is competent, things are working out before they make that investment of time and funds into sponsoring them for a green card. I have had over the years a few clients who were like, look, we don't really want to get involved in green card sponsorship. And so that relegated doctors to having to look at physician national interest waivers or EB-1 petitions that maybe they weren't fully qualified for. And it made things a little bit uncomfortable. And I think those employers found it very difficult to retain doctors because they wouldn't engage in the sponsorship. And so I encourage all of my employer clients to set a policy, have a basis, so that especially when I consult with the doctors, I can tell them what the policy is, but to be open in that communication. I think it's the same thing with the O's that we were just talking about. If you're recruiting a doctor who's on a J1 and we can't get a waiver this year, so we go and we do an O, I mandate that my employer clients have a plan for when are we doing that doctor's waiver. We are not going to let that doctor sit out there for 3 to 6 years with no waiver because you're recruiting new people, right? We want to make sure that we have a slot that we're going to put them in to get the waiver for the next year. And that potentially could impact your recruitment the next year or the year after. So if you're going to have that doctor on an O, like we want to make that commitment because again, for the long term, for retention purposes, it's really important to make sure that that doctor is taken care of because not having the waiver is just a really big source of anxiety.
Yeah, I would imagine. I mean, some folks wait to the last minute to do some of the paperwork and the things. I can't imagine the anxiety that they're feeling. But having that kind of hanging over you, it is a lot of stress for these folks. One thing you mentioned earlier, I just want to touch on it really quick. What's your advice when you are recruiting someone on a waiver that needs assistance and they may or may not want to travel outside of the U.S.?
So most of the time when we're working with a physician who's getting one of these underserved area waivers, our goal is to ensure that that physician can stay in the United States all the way through the process. Most of the time that's possible. Through different strategies and kind of working the system a little bit, we usually can make that possible. And we try to be a little bit aggressive about it. On the other hand, there are times where there's just nothing we can do, right? If a physician signs a contract in May or June, right before they finish residency or fellowship, and they don't have a board exam coming up that year for which they can extend their J status, so literally they might have till the end of July to stay in the U.S., being able to keep them here beyond that is really, really challenging and may not be possible. So then we try to advise folks on what they need to do to travel abroad and the timing of when they might be able to come back. Right now, in this moment, we are really trying to do everything we can to not have folks travel. So I have a couple of clients who have hard stops at July 31. And so we're trying to make sure that we do whatever we can to file their H-1B petitions so they can stay in the U.S. while the waiver process plays out. So yeah, it's a huge priority of ours is to ensure people don't need to travel. But then at the same time, if they do have travel plans over the summer, right? Sometimes I'm counseling a doctor. I'm like, well, we're going to do whatever it takes to keep you here. And they're like, okay, but I want to go home for July and August. And I'm like, Oh no. Okay, let me put my other hat on right now and explain to you like how the travel is going to work and what the timing considerations are, and that September 1 start date might be a little bit in jeopardy if you're delayed in getting your visa to come back to the States. So let's, kind of play out the scenarios. So we do have folks that want to travel, and we try to make that possible too if we can.
In most cases, if they've been here for the residency and then potential fellowship, they've been here for several years. They probably haven't gotten a break to go home for an extended amount of time to see their family. And so, all of us would miss seeing those folks. It's just not wanting to put their future employment in jeopardy in those situations.
Yeah, exactly. Right now, it's such a hard time because I loathe having to tell people not to travel, right? Like, I was born and raised in the United States. I can go see my family anytime I want. I can hop in the car. I can get on a plane, like whatever it is. My clients don't have that luxury. And so I feel like I'm in a really awkward, privileged position to tell them, no, don't go to your sister's wedding because, on the other hand, so I don't tell them that unless I have a really good reason. So COVID was a great example. There were travel bans all over the world. And there were large chunks of time during COVID where I had to tell people, look, if you go, I probably can't get you back here. Just don't leave. And right now, it's not that dire, but I have been cautioning clients, individual physicians, like, I would prefer you not travel right now. If you could postpone your trip to the summer or something, I think we'll have a little more clarity. But right now, things are a little bit topsy-turvy, and you may be delayed or denied on your way back in. And so here are some things to know, and I'm counseling them on some things to know about coming to the US border and how to navigate that, but it really gives me anxiety. I'm definitely not in a position right now to say to people, oh, sure, go, like no problem, right? I want them to understand there may be additional risks.
So since we jumped right into like policy and regulation, we'll just keep going with that theme. So you said, you don't have a lot of clarity right now, but upcoming policy changes for US immigration law, maybe potentially, I don't know if there are state things that are being changed, but anything that recruiters should be paying close attention to in 2025.
Yeah. Right now on the employment-based immigration front, thankfully, and whatever you do for superstitions, like do that now. If you get a knock on something, blow on something, I don't know, but just do all the superstitious things. Right now, things are largely quiet. Filing petitions, things are happening the way they should in the timeframes in which they should, and we're very grateful for that. We do expect at some point there are going to be some changes that are going to come either by regulation or by policy change. One is that travel ban I just mentioned. Specifically, I expect this administration to try to put some limits on third-party employment. So this is like employment by staffing companies. They tried the last time around. The changes that they tried to implement were thrown out in court. We expect they're going to try again. There was a regulation that went into effect in January, right before Inauguration Day, that did some good things, but also did some more difficult things. And that did already start the road down to putting some additional evidentiary requirements on cases filed by third-party employers. I haven't really seen that upend my practice to date or cause any major issues, but it's there. So that could be expanded. We also expect that the government is going to try again to increase prevailing wage calculations. So they tried this last time also basically to try to make it so that H-1B workers who have to be paid whatever the prevailing wage is or higher than the prevailing wage for that job in that location, they tried to significantly increase those last time to the point that even our doctors who are well paid were looking like they were on the low end of the pay scale. We think they're going to try something like that again. Again, of course, we don't know when or exactly what that's going to look like. The last time around, it was thrown out in court. We'll see what happens this time. But those are definitely two policy changes. I do think we'll see more green card interviews. Right now, if you apply for a green card based on your job's sponsorship, you don't have to go for an interview with a USCIS office. We expect that that's going to start to ramp back up. It hasn't happened system-wide yet, but we are hearing anecdotally about interviews here and there. On the flip side, like those are all kind of like negative things, right? There is one relatively positive change, and I know, Christy, you and I have talked about this a whole bunch, but that same H-1B regulation that I mentioned that went into effect in January, at the same time it did some things that were a little bit frustrating. It also opened up H-1B sponsorship to different kinds of employers. In the past, H-1B sponsorship could only be undertaken if there was a W-2 employer-employee relationship between the petitioner and the beneficiary, between the sponsor and the employee. That's gone away. And in its place, we have a requirement that says there just has to be a bona fide job offer, meaning that this is a real job offer. But contractors are allowed to now be H-1B sponsors. And so we think that this opens up the door to more large-scale H-1B sponsorship by 1099 employers, which can open H-1B sponsorship to the locum field, which could really be a game changer. And I think it doesn't change the other essential requirements of the H-1B sponsorship, like the cap, like the prevailing wage requirements and all of that. So there are a lot of details to be worked out. But the benefits and the upside and the excitement that I feel about potentially being able to open up employment or hiring of international physicians in the locum world, I think that's a real positive that came out of that regulation.
Is there a requirement on number of hours? I know that, the 40 hours worked at a certain address and you had to ultimately prove that that's where the physician was providing service. Is that not a requirement that makes it easier for staffing companies?
Yeah, so that requirement really only applies to J1 waiver doctors. And so my thinking on this is that it's a really great opportunity for moonlighters, people who might already be in H-1B status for another employer. They're doing a J1 waiver somewhere else. They want to moonlight, and there's a locum agency that is willing to bring them on to do that moonlighting. It makes the process a lot more streamlined, a lot easier to navigate. And I think as an initial foray into that sponsorship, that is really a great place to start. And so then we can have any amount of hours. As I mentioned, there are pay obligations and things. So there are definite compliance details to work out. But just the ability to even consider it is something we didn't have before. So it's really exciting.
Yeah. Health systems often hire moonlighters themselves, usually on a PSA type of agreement. Is that where you would see, health systems being able to utilize that new rule?
Yes.
I think that's great. I mean, anything that we can open up pipeline to provide care is the ultimate goal. And I do think these folks, they're wired to work. They're ready to do that. And I think most folks want to go above and beyond, and it gives them an extra avenue for not only money, but then potentially to share their knowledge and be a resource to another community or hospital.
Do you want to know when to do what in your job search? First Practice, PracticeLink's resident and fellow career guide, teaches you 10 easy-to-follow steps every prospective physician needs to find their dream practice. And best of all, it's completely free at firstpractice.com. Becoming a physician is hard. Finding a job doesn't have to be. Thank you for listening. Now we'll return to the podcast.
So let's talk about some of the pitfalls. What type of legal pitfalls should healthcare organizations be aware of when sponsoring visas for physicians? And I know we hear a lot about international nurse grads coming over and making it or not making it. That process seems a little stuck right now, but what should we be aware of to avoid?
I put these into kind of two buckets. The first bucket is timing, delays, travel issues. Early on when we talked about challenges, timing, both government processing times, when physicians sign contracts, how to navigate the process depending on how much time that they have before they finish fellowship. Even with lateral transfers, sometimes timing's an issue. You have a doctor who hems and haws on their contract, and they sign a contract 3 weeks before they're supposed to start work, and we have to really rush on an H-1B petition maybe to transfer that person. So timing could be an issue. Government delays, always a potential risk. Sometimes those are navigable. Sometimes it's something you just have to work through. And that's specifically true with travel. One of the things with travel is even if a person is here and they're working legally in the United States, in order to get back into the States, unless they're a Canadian citizen, they need to have a visa stamped in their passport that is in that same category. If they're here and they're working on an H-1B, if they leave the United States, they need to have a visa in their passport that's stamped H-1B so they can get back in. It's like their ticket of admission back into the States. One of the things that we expect to continue to see more of is something called administrative processing, where a person goes to the U.S. Embassy in their home country, they apply for their visa, they do everything right, and the government puts them into an extended background check where they just tell them there's some kind of administrative delay in getting them back. Those can be extraordinarily challenging to navigate. The State Department's official position is just, you need to wait. And you could be waiting for a week, you could be waiting 10 days, you could be waiting 10 months. And so there are various ways to navigate that, but travel delays can really be a challenge. And so I always tell doctors, if you're going to be traveling abroad and if you're going to be visa stamping while you're abroad, please make sure your employer knows that they might have to bring in some kind of coverage for you if you're delayed in getting back, so that the employer can ping their resources, whether it's locum coverage or they have a float pool they can go to or something. Make sure that they have somebody on tap for that time just in case. It's way better to do that than to not speak up, get delayed, and then your employer's scrambling because you have patients scheduled the next day. So at the same time, from the employer side, I always say, look, remember, and it's like what you and I were discussing earlier, Christy, these folks, may not have been home to visit their family in years. This is their one opportunity to go spend 3 weeks at home and visit all their friends and family. Please don't make them feel guilty for doing that, right? It's not a personal failing that they traveled and they had to go for visa stamping. So we all need to be on the same page about that. So that's a big pitfall that everybody just needs to be aware of. The other big bucket of pitfalls is compliance. No matter what you're filing, whether it's an O, whether it's an H-1B, whether you're sponsoring a green card, there are documentation requirements, there may be pay requirements, there may be requirements about the locations where the individual is working, and there may be contract terms that you need to comply with as part of their immigration process. These are things that your immigration lawyer will kind of let you know about as you go. We send a lot of form emails out with all of that information. Read them and ask questions if you don't understand or there's something you don't know, because we find out sometimes operations will move a doctor from one location to another. And by the time that trickles up to the corporate folks and down to us, the person's been working at a location they shouldn't have been at for a month sometimes. And that's a big risk for everybody involved. So compliance issues are huge and something that really should be taken seriously. Don't assume nobody will ever know. Somebody's going to know.
Yeah, they always find out. And I have heard of instances where they do show up to verify the workplace of that physician. So it is not unheard of that somebody would show up to do that verification. You talked a little bit there about the importance of collaborating across the team. So often, physician recruitment team is outside of HR, usually, or within a practice setting. And then the legal team is a whole nother entity. But I've always worked with really highly qualified external immigration law firms. We didn't have that embedded in our health system. But how do you manage that level of collaboration? Because there are components after the start date and the person is there and onboarded and up and running that you still need to communicate with somebody. It's probably not that initial recruiter. But how do you work through that? And how would you kind of advise our listeners from that talent acquisition team to kind of address that or streamline some of that process?
Great question. And it is common for immigration counsel to be external just because it is such a niche practice. A couple things. Obviously, I think it's really important both from the law firm perspective and from the organization perspective to remember that everybody's on one team. We're all working to the same goal. I have some clients that loop me in from their pipeline all the way through onboarding and beyond. I really love having regular monthly calls where we talk about all the people, kind of know what's going on. Everybody's on the same page. And that gives my client the opportunity to ask questions of me. I come armed with all the information from my team, so I know what's going on all the cases. And I find that those are really helpful communications to kind of know. We have some employers that we update regularly by email as well, but just that regular communication on updates. I find in terms of that, though, having one or two primary points of contact at an employer is really helpful. So it's not that I'm not going to ever hear from the recruiters. It's not that they're never going to have communication with our office, but there are going to be one or two people who all the way through, recruitment, contracting, onboarding, beyond, that are going to be in the know and will know what's going on. It avoids having too many cooks in the kitchen, but it also makes sure there's somebody who has ownership. One of the most frustrating things from our perspective is when the people or person at our client who's responsible for the immigration function is either scared to death of it or just doesn't want to internalize any of it. So we might be doing the same processes 2-3 years going on, and all of a sudden they come and start asking us questions that shows us that they really have no idea what we've been doing all of this time. And, it hinders that relationship. So I think that it's great when the folks who are dealing with the immigration function, you don't have to be me, right? You don't have to be an expert and devote all your living hours to it. but it helps to kind of take ownership of it and want to do the best and to get over that fear factor.
It's like the old saying, there's not a bad question or a wrong question to ask. In this case, you should be asking more and more questions, get defined timelines, and then have transparency through the process. I want to go back really quick. One thing you mentioned, we've talked about their need to go back and want to see family. And often these are extended trips. Number one, it takes a long time to get there by airplane, by usually airplane, right? But it takes a long time to get there. And so what I found, I had inflexible PTO policies. They only got so many days off. And in the event that they would like to take a 3-week vacation and, anything over a 3-week popped into some other category of FMLA or something outside. Is there anything, do you have advice on that? Or maybe just offering some flexibility in terms of a retention component that, sure, they're gone for these 3 weeks every 5 years, but you have a provider that's right there all the time. Have you encountered that folks maybe don't take job offers because they're like, I have to go home for some time?
Yeah, I've seen both ends of the spectrum. I think most of my employers, I haven't seen people butt up against that PTO limit too frequently. So they're typically pretty generous with that. And I would recommend that. And to be a little bit flexible with folks, especially if there are unanticipated delays in their return, right? The initial plan of a 3-week trip, okay, that's one thing. But if they go on that 3-week trip and they can't come back for another 3 weeks because there's a visa delay, I'm trying to find a way not to penalize the physician because it's not something that was necessarily their fault. They didn't just decide to extend their vacation by an extra 3 weeks. So I think that's important. So I once had a physician who's negotiating a contract with an employer and they asked for 12 weeks of vacation time during the year. And I was like, okay, I have a problem with this because this physician's doing a J1 waiver, which requires them to work full time. And I am totally cool with doctors taking vacation and not having to pay back that time, right? That doesn't mean that the doctor can't ever take days off, that 40-hour-a-week requirement. But 12 weeks out of the year is like a quarter of the year, basically. Like that's too much vacation time, right? Then we're talking about a little bit of overreach. And the employer was like, thank you for telling us that because we didn't want to give it to them and we thought maybe we had to. And I was like, no, you don't have to. So there is such a thing as overreach. I've only ever seen that one time. But most physicians, I think I've seen 4 to 6 weeks vacation in the year, something like that. And that seems to be pretty standard and something most doctors can operate within.
And so when you think about 4 to 6 weeks, so ideally that's 20 days, 20, 30 right in there in terms of days, because usually would just count the weekdays, right? So we've talked a lot about the importance of timing and we've talked about transparency and collaboration. There's a lot of papers that have to get filled out. I'm assuming papers, hopefully it's online now. Is there any technology that's really transforming immigration law and maybe the processing is where we usually hear about the delays? Or other platforms that are out there that folks could use internally or speak to some of the things that your firm uses?
Sure. So USCIS has been trying to move online with their filing system. I would say it's very rudimentary and it's not necessarily user-friendly. I do file all of my clients' applications for citizenship online because even though the filing process is frustrating, I find that the streamlined processing on the back end is really good. We theoretically can file H-1Bs online, but the process is really wonky. And I haven't yet subjected too many of my clients to that wonkiness, but we are heading in that direction. And all of our H-1B cap registrations, when we go through that lottery, those are all online. Again, it's a little frustrating, but it's usable. So most of what we do is actually still done on paper. But our preparation of those applications is entirely done electronically. So basically, we're interfacing with our clients through our portal and through email. We're preparing the entire applications online in our system. And then when it's time to file, we print them out, review, sign, and ship. Things work pretty well. In terms of technology, the other thing I'll mention is since the pandemic, a lot of J1 waivers now we are filing online or via email with the various different state and federal agencies. And just this past year in October, the State Department started mandating that all of the J1 waiver recommending agencies, so all the state departments of health, all of the federal agencies that support J's, that they all start to send their recommendations to Washington via email. There have been some hiccups with it. Some programs have found that their emails have gotten stuck somewhere, but other cases have kind of sailed through. And the Department of State a couple of years ago started notifying us of their waiver recommendations through email. So there have been some transitions to more digital and electronic communications with the government on J1 waivers, which I know all of that sounds really like baby steps, right? Like we've all been using email for 30 years or something. And the federal government's like, ooh, we can use email now. But this is like giant leaps in terms of government communication. So it's really moving in the right direction. In our office, we are a pretty tech-forward firm. Our firm has a spin-off company called VisaLaw.ai, which develops AI tools and other computer apps and things for immigration lawyers and in our space. So our office robustly uses a product called Gen, which is a generative AI program specific for immigration law. It's a private closed program, so none of the information we input there is used in ChatGPT to train other models. It's only used internally. And we use it a lot for research. We have a lot of resources that it has been trained on, and we use it as a drafting tool to help us write certain letters and things that are pretty time consuming. So it helps us be more efficient. So it's been a really great addition to our tools, and our staff are all trained on how to use it. So that's kind of an exciting thing that our office uses pretty robustly. We have various other online tools. We recently switched to a new case management platform that allows all of our clients to log in. Our employers can see a whole dashboard of all of their employees, expiration dates, timelines or progress lines for what's going on in different cases. And the individuals can do the same thing on their own cases. So they'll see my H-1B is 25% done or things like that. So it's still ramping up in our office. We just started using it December, January, February. So the learning curve is still in full swing, but we're really excited about it and our clients are loving using it. One of the cool functions it has is people can upload their documents into the system and it automatically reads them, names them, and puts them in the right place. So it saves our team a tremendous amount of time in doing that. So if you send us, 5 scans all named SKN 523, you don't name it, this system will name it and identify the document. So it's been a really great tool to have so far.
Yeah, that's a great use case for AI. And then the technology really creating that efficiency for the firm. I could see where medical records, that would be the same. You're scanning a lot of documents and either saving them, or I remember doing that way back in the day when I worked in transcription. So that would be a very nice tool to have. So I'm going to wrap us up for today. We started talking about immigration support as a recruitment lever or tool in your toolbox, right? So how can recruiters better advocate for immigration support when their leadership teams may be hesitant or unfamiliar? Maybe what advice would you give to folks who are trying to build that more inclusive workforce, but coming up against some friction and then just the preconceived notion of it's difficult and time consuming and expensive?
A few things. First, I would say, above all, emphasize the need to recruit the best providers. If you have the ability to recruit international candidates and you don't consider them, you could be ignoring real potential rock star providers for your system, and somebody else is going to scoop those folks up. So just as a competitive thing and as a patient satisfaction, patient service thing, make sure you're considering all of the available providers so that you're not leaving anybody out. In terms of costs, typically the cost of sponsoring a doctor is probably a fraction of what you're paying that doctor. Most immigration law firms charge flat fees for services, so you'll know on the front end exactly what things are going to cost. You can budget for it. You know what you can absorb. But I think the other thing, and we talked about this a little bit earlier, cutting through the fears, right? Fears of cultural mismatch, fears of physicians leaving too quickly. I can tell you, every year we file hundreds of H-1B extensions for doctors. And what that tells me is that those physicians are staying in the same location with the same employer in the same position 3 years and then another 3 years and then maybe another 3 years, and they're sticking around. And so when the environment is hospitable, when people are welcoming, when they feel like they're a part of the community, right, they want to stay. Retention is huge. I think sometimes folks think about retention very generally, but I think specifically with your international workforce, retention maybe takes on a little bit different tenor. And so you need to think your retention folks, the folks that are creating these policies and things, really need to think about and even talk to your international providers to find out like what makes them tick. What are the things that might make them stay? And it may not be a gym membership. You know what I mean? Like, I think that really thinking about cultural sensitivity, making sure people feel welcome is really huge. And then the other thing, and I've said this a few times, but you got to dispense with the fear of failure. It's a self-fulfilling prophecy. When somebody is timid and they're not taking ownership of the work, when your C-suite feels like, oh, well, if we deal with it, somebody's going to get deported. We can't do that. It's just too much to take on, too much responsibility. Well, then somebody's going to drop the ball because nobody wants to really put themselves out there to do it. You need to commit to the process, learn how it works, lean on your immigration counsel, use them for the experts that they are, for the resources they can provide, and go into it boldly and not fearful. I think that is really a recipe for success.
I've always had success recruiting international medical graduates and watching them succeed and thrive in the U.S. and being able to provide that service. So I appreciate your support that you provide. And we know we couldn't do it without attorneys like yourself to get us through. So appreciate that. On behalf of PracticeLink, I want to thank Elissa for appearing on the Workforce Wisdom podcast. For our listeners, please feel free to check out and reach out with any thoughts, insights, or questions about anything we covered today. You can email plmedia@practicelink.com. If you're a physician or provider looking for immigration law advice, we have additional information in our resource center on the practicelink.com website. My name is Christy Bray. Thank you for listening to Workforce Wisdom.